and codification of international law. And an important part of this is the contribution of Commission members from ALCO member states and the contribution of ALCO member states themselves to the work of the Commission. The Asian and African members of the International Law Commission have undoubtedly made and continue to make a valuable contribution to its work. Their presence is essential if the Commission is to be truly representative. It is unfortunate if those elected by the General Assembly do not attend regularly or at all. Of course, there's no doubt good reasons for that. We are all very busy. But states too have their role to play. And I would encourage all of you to respond to the various requests for information, both in writing and in the Sixth Committee debate. I know from personal experience how difficult this can be for busy government lawyers, but it is important that they contribute to the long-term development of international law, as well as dealing with day-to-day crises. One thing that states can and should do, if they wish to influence the development of international law, is to publish their own state practice. I know that a number of member states of ALCO do that and do it very well on a regular basis, but it would be very good if ALCO could encourage its members to publish practice systematically. Madam President, Mr. Chairman, ladies and gentlemen, I thank you very much for your attention.
Thank you, Sir Michael Wood, for giving us an overview of the various topics before the International Law Commission and identifying the key issues which are under consideration in each one of those topics. Now I'll give the floor to Mr. Narinder Singh, who's also a member of the International Law Commission, and we at ALCO know him as former president of ALCO and also as the former legal advisor of Government of India. You have the floor, sir.
Thank you, Madam President. Madam President, Mr. Secretary General, Excellencies, distinguished delegates, ladies and gentlemen. I thank the Secretary General for inviting me to this special meeting on the work of the International Law Commission at ALCO's annual session. Sir Michael Wood has already given a very detailed account of the work which was done by the Commission during the current year. He has also highlighted a number of issues which have been earlier considered by the International Law Commission and which still remain relevant for ALCO member states. I would like to refer firstly to the Convention on the Jurisdictional Immunities of States and Their Property. This is a very important convention recognizing the principle that states cannot claim immunity for their commercial transactions. This convention was adopted after extensive consideration over quite a long period, both in the International Law Commission and in the Sixth Committee. The contribution by the ALCO member states and ALCO experts, both in the Sixth Committee and in the Law Commission, has also been highlighted by Sir Michael Wood. Now, India has signed this convention, but is not yet ratified. However, it may be noted that India, in practice, has already been applying the convention and has been relying on its provisions. The provisions of the convention have also been considered by Indian courts in giving decisions. I would just like to go into detail here. Under the Indian law of civil procedure, any person wishing to file a suit against a foreign government or a foreign mission in India requires permission of the central government to file that case. Now, while considering whether or not permission is to be given, the government takes into account the practice of states around the world, as well as the evolving principles of international law, And this convention has been considered by the government. It has also been considered, pleaded before the courts as one of the grounds which the government has considered while granting permission or refusing permission. Because in many cases, when permission to sue is not granted, the parties approach the courts. And the courts have also agreed that the trends and developments in international law must be taken into consideration by the government while deciding whether or not to accord permission. And among those trends, the courts have also examined in detail the provisions of this convention. I hope that ALCO member states would take action to ratify this convention so that it comes into force and becomes effective. Some other topics on which the Commission has concluded its work, but which are relevant for the ALCO members, as also highlighted by Sir Michael Wood, are expulsion of aliens, reservations to treaties, and the draft articles on state responsibility. I would commend these texts to the member states for consideration, for making comments, submitting comments wherever necessary, and also to contribute to participate in the discussions on these important items. Coming to the topics which are under consideration by the Commission currently and which are also on our agenda today, I will first refer to the immunity of state officials from foreign criminal jurisdiction. This topic is of great practical significance and is also politically very important. In the ILC, quite different views have been expressed by the members. A number of members have highlighted the importance of the need to end impunity for serious crimes, and on that basis, they advocate a very restrictive application of immunity even to high state officials. However, other members have emphasized the basic purpose of immunity as being to ensure the independence of high state officials in their interactions with other states and the conduct of international relations. And on this ground, they have referred to the historical practice to justify the continuation of immunities. The Commission has agreed that the Troika, that is the heads of state, heads of government, and the ministers for foreign affairs enjoy full immunity, that is both immunity for personal acts as well as official acts immunity. However, some members in the ILC still continue to question the personal immunity granted to the ministers for foreign affairs on the ground that there is need to restrict immunity and that immunity should apply, full immunity can apply only to heads of state and heads of government. Other members, including myself, prefer a wider circle of high officials based on their functions. Especially in the modern world, where the conduct of foreign affairs or interaction with other states is not limited, unlike traditionally, to the ministries of foreign affairs and can cover a wide range of state departments. So this is one topic, I think, which is of great importance to all the member states, and we look forward to the further developments in the law and to the further reports which the Special Rapporteur will be coming up with on the more complex issues regarding the definition of official acts and the immunity rationale materiae, which we hope will come up next year. And then we would also have to examine the very sensitive issues of what could be the possible exceptions to immunity, as for example, the core crimes of international concern. The next topic I would like to refer to is the protection of persons in the event of disasters. The Special Rapporteur, Mr. Valencia Ospina, has so far presented 6 reports. In his 6th report, which he presented this year, he has focused on the disaster risk reduction, and the Commission adopted 2 articles on this. This report has emphasized the need to take measures to prevent disasters before they occur, and to make preparations to ensure that if and when disasters do occur, they can be dealt with as effectively as possible to eliminate, or at least to reduce and mitigate, the effects of the disaster. In the draft articles, which have already been adopted in previous sessions, the Commission has recognized the concerns of several members as well as the states in the 6th committee that the state on whose territory the disaster occurred, being the state which is most immediately involved and also being the state which is in a position to assess the extent of and the severity of the disaster, as well as to assess the needs of those who are affected by the disaster, it is this state which must decide as to the action which is required to deal with the after effects and the assistance to the victims. The articles also recognize that it is the affected state which has the right to decide whether in dealing with the disaster it would require assistance of foreign states, and if so, the extent and the nature of the assistance which it requires. And these draft articles also recognize that even when foreign state assistance is sought and received, the affected state would be the one which will coordinate all the efforts and is in charge of all matters relating to the response to the disaster. The topic of customary international law has already been explained in great depth by Mr. Michael Wood, who is also the Special Rapporteur and who presented his first report this year. So I will not go into details on that. Thank you, Madam President.
Thank you, Mr. Singh, for your presentation. Now I will give the floor to Dr. Rohan Pereira, who is also a former member of ILC, and presently he's chairperson of the Eminent Persons Group of ALCO. You have the floor, sir.
Thank you. Thank you, Madam Chair. Mr. Secretary General, colleagues on the panel, distinguished delegates. After those presentations, including the introduction by the Secretary General, my intention this morning is to express some observations and make some comments, primarily on the topic, the all-important topic, as underlined by Sir Michael Wood, of immunity of state officials from foreign criminal jurisdiction. A legally complex and a politically sensitive topic. And my starting point would be to set the backdrop, as it were, would be the excellent preparatory work accomplished by the previous Special Rapporteur, Mr. Roman Kolodkin, with regard to the general orientation of the topic. Special Rapporteur Kolodkin put in considerable work, and with regard to the general orientation, and his starting point was that he was approaching this question, particularly in regard to the question whether there were exceptions to immunity rationale personae, from the perspective of the lex lata, or the law as it exists, rather than de lege ferenda. That was the approach of the previous special rapporteur. When his